Welcome to the Defending Heroes podcast. This is Matt James, attorney and founder of James Defense. In this podcast, I'm going to discuss the 7 common myths involved with military sexual assaults, or Article 120 UCMJ. Now, military sexual assaults are a hot issue with Congress and with senior commanders in the military. And not surprisingly, in part because of this, a lot of bad information has infected military culture. If you are a military member, you owe it to yourself to know the facts about military sexual assaults. One of the top myths about military sexual assaults is if someone says they are raped or sexually assaulted, they are telling the truth. This is absolutely false. Sexual assault or rape allegations are, in fact, fairly easy to make up. You don't need to have any injuries or other evidence to prove your allegation. It's very simple for somebody to come forward to a military commander, to the SARC, or to military investigators and claim they were sexually assaulted. All they need is their own word. Now, many sexual assault response coordinators, commonly known as SARCs, teach that most sexual assault claims are in fact true. This is something that they've been briefing many military members on, and that's one of the major sources of this myth. However, they don't put forth any facts or data to support this. In fact, according to the Innocence Project, 75% of cases that courts have overturned based on DNA evidence involved eyewitness testimony. And what this means, simply put, is that eyewitnesses get it wrong, even when they believe they are telling the truth. With military sexual assault, people making claims often have many reasons to lie. The most common cases involve a person cheating on his or her spouse or boyfriend and then claiming they were raped later. Another common case involves a husband and a wife going through a divorce or a custody battle. So just because somebody claims that they were sexually assaulted doesn't mean they actually were. The second myth is sexual assault investigations and prosecutions are about finding the truth. In theory, this should be true, but in practice, it is false. Most law enforcement members have a guilty until proven innocent mentality. They will go through great lengths to prove someone guilty, but rarely attempt to find the evidence that will prove someone innocent. And I know this because I've worked with police and military investigators over many hundreds and hundreds of cases. And in just about every single case, the police and military investigators have gone to great lengths to find evidence that'll prove somebody's guilty of an offense, but very seldom put in that kind of effort to find evidence that proves that somebody is in fact innocent. Military prosecutors or trial counsels often have a similar attitude. Unfortunately, some trial counsel are often more eager to win than to get to the truth. In some regards, this is partly due to their inexperience. Yet even senior prosecutors claim that their job is, quote, prosecuting sexual assaults. Now, I would have hoped that senior prosecutors in the military would see their job as getting to the truth and providing a fair trial. Unfortunately, this is not the case. And as much as we would like it to be the case, we have to deal with the facts and the law as we're presented. Sadly, I've defended sexual assault cases that were investigated at an Article 32 or a pretrial investigation, and the investigating officer found that there wasn't enough evidence to go forward. Nevertheless, commanders decide to go forward, despite the fact an independent officer has looked at it and said, hey, look, the evidence isn't here. And this is because the amount of proof you need to take someone to a court-martial is extremely low, which is somewhat frightening for the average person because the results of a sexual assault conviction are so enormous. We're talking about jail, a punitive discharge, and registering as a sex offender. The third most common myth is I should cooperate with law enforcement. Absolutely false. As I noted, law enforcement seldom looks for evidence that proves someone innocent and will go through great lengths to prove somebody's guilty of a crime. Law enforcement in the military works for the commander. They will usually be looking to prove their case and find evidence that you did something wrong if you're being accused of sexual assault especially. On the other hand, if you're innocent, military law enforcement will never believe you. They always claim you're lying, and in fact, they teach some of these investigators to try to read body language, which is so unreliable it's inadmissible in court. It's essentially a game they play that if they feel your body language is deceptive, they will claim that you are lying to them. Often they may twist your words or statements to make you look guilty, in fact, when you're not. And this kind of goes back to the My Cousin Vinny, as I've argued it many times, in which, in that case, somebody makes a fairly innocent statement. The police say, well, you shot the girl. And then the person is surprised and says, oh, I shot the girl? And then when it comes time for trial, the police officer says, and he said to me, I shot the girl, making it look much, much worse than it is. The worst part about military investigators is they can legally and will lie to people to get people to try to confess to a crime. So they'll say that they have evidence they don't have, and sometimes they'll just make things up. So if you're ever confronted with a military investigator or military police, you should always remain silent. If you need to make a statement, you could make a statement through your military defense lawyer. I've been involved in criminal trials for over a decade, and I can say that 99% of the time, making a statement to law enforcement hurts you more than it will help. The fourth myth is that if a man and a woman are both drunk and have sex, then the man raped the woman. This is also a myth, unfortunately, being spread by the sexual assault response coordinators. The law typically requires two things for a crime: bad acts, known as actus reus in the fancy Latin, and a guilty mind, or mens rea. Typically, this means you have to do something wrong and know that you are doing something wrong. As of this post, or this podcast, there is no law that says that having sex while drunk is either one of these things. Article 120 of the UCMJ says a person cannot consent if they are asleep or unconscious. It also says that a person may be incapable of consent due to impairment by any drug, intoxicant, or other similar substance, and that condition is known or reasonably should be known by that person. So what does this mean in simple English? You can be too drunk or too high or too under the influence to consent. But what this requires is a bad act, somebody having sex with somebody who's too drunk to consent or too high to consent or too intoxicated to consent, and a guilty mind. That person needs to know or should know that that person is too drunk or too high to consent. The key question in these cases is not whether the people were drunk, but whether they're too drunk to consent. I mean, we all know that people often do things when they're drunk that they later regret. And the reason this often comes up in Article 120 cases is that people will have sex with somebody they shouldn't have. As I've mentioned before, they've cheated on their spouse or cheated on their boyfriend, or they're having sex with a superior. And then later on, when this comes to light, they claim that they were sexually assaulted. The bottom line about this myth, though, is that you can still be drunk and consent to sex, whether you are a man or a woman. The fifth most common myth, and one of the most disturbing to people, is that people who make false sexual assault or rape claims go to jail. This is almost always false. Perjury, or making a false official statement, or in the civilian world, filing a false police report, is an extremely difficult thing to prove, especially regarding sexual assault claims, because, as I've mentioned before, they're very easy to allege. You can just go in and say, hey, look, this happened, without any proof. It's very difficult to prove that they are completely lying. In addition, there is no public outrage at false sexual assault claims. I mean, Congress gets very upset about data that suggests there's sexual assaults, data that's inconclusive at best, but they are completely unconcerned about people making false sexual assault claims. And the reason I hit on this so hard is before I became a military attorney, I was a civilian prosecutor, and I investigated hundreds of these things. And 99% of the time, there either wasn't enough evidence or there was pretty strong evidence that the claims were not entirely true. However, in this day and age in the military, it doesn't matter what the evidence is or whether the allegation is entirely true or not. If somebody's making an allegation of Article 120, chances are it's going to go to a court-martial. The sixth most common myth is that you should talk to your friends and family. You should never talk to your friends and family about any facts regarding any charges you may be facing. Friends and family are often turned into witnesses for the government, whether they want to or not. If you call up your mother and you say, hey, I was at this party and I was drinking and now this girl claims that I raped her, well, the government could go to your mom and have her testify that you were at the party and that you were drunk. Now, again, you may want to make a statement like that, but you should do so through your attorney. Imagine, for example, if you were under the age of 21. Now the government can charge you, in addition to an Article 120 sexual assault crime, they can charge you with drinking while underage. And if you think the government won't do it, well, I can attest again, having been the government and having been through many of these cases, that the government will tack on whatever charges they can to make sure their 120 prosecutions go through. If you're facing military court-martial charges, the only person you should be discussing your case with is your lawyer. Let your lawyer do the talking. That's why you have a lawyer. Your lawyer should talk to the witnesses. Your lawyer should gather the evidence, and your lawyer should do all these things on your behalf. The seventh most common myth is there's no way to protect yourself from false claims of sexual assault. And this is completely false yet again. False claims usually arise when the person making the allegation has sex and then regrets it, or when they have mental problems. And these can, according to the experts in the field, people who have prior histories of sexual abuse, this can color their perceptions, as they say. And they may see sexual abuse or sexual assault where, in fact, there isn't any. But the bottom line for this is that typically treating people respectfully, don't have sex with somebody you shouldn't have sex with, and using your common sense would often lead to another outcome. Some of the people that are most commonly targeted for what I would consider to be false sexual assault claims are people that have lots of sex with lots of women, or people that are disrespectful towards women. And just simply put, going back to the basics of keeping yourself out of trouble, just being a good person will go a long way. Thank you for listening to my podcast. If you need more information, please visit my website, defendingheroes.com or jamesmilitaridefense.com. Once again, this is Matt James. Thank you and have a great day.